Well, good morning to everyone and a very warm welcome to Quadrant Chambers. This is the first shipping quadcast of 2021. It follows three very successful sessions from last year, which for anyone who hasn't seen them, and I do recommend them, can still be accessed via our website and our YouTube channel. The focus of today's session is a judgment of Mr. Justice Foxton in a case called the Sea Challenger, which was handed down just before Christmas. While it's not attracted very much publicity thus far, it's fair to say it's one of those relatively rare decisions which raises and addresses not just one difficult and important issue, but a range of them. As we'll see over the next 30 minutes or so, it covers tricky issues such as the circumstances in which a ship owner is taken to have given a pre-contractual representation, in this case as to speed and consumption, the level of knowledge required for there to be an affirmation, the effectiveness of a reservation of rights on conduct that would otherwise be affirmatory, how the court should exercise its discretion to award damages in lieu of rescission if that would put the innocent representee in breach of contract, and also the measure of damages in misrep. So a series of tricky issues. Now, to help us distill the essence of both the questions posed and the answers given by the court, we have first of all Chris Smith QC, who was in fact successful counsel representing owners in the case and who I'm sure will be known to most, if not all of you. Then we have Mark Stiggelbout, or the Stig as we prefer to call him, who is consistently praised in the directories, amongst other things, for being well ahead of his years, great to deal with, and as having fantastic knowledge. And last but very definitely not least, we have Celine Honey, who joined Chambers in October of last year after impressing everyone during a pandemic pupillage, and who's been brave enough to join us for the first time, though she said to me it was on the express basis that she wants to field all the super difficult questions that you will undoubtedly have. And on the question of questions, if you do have any for Celine or heaven forbid for anyone else on the panel, if you could use the Q&A button at the bottom of the screen, we'll deal with them at the end of the session. Now, before handing over to the panel, the facts can be briefly summarised as follows. Until October 2016, the owners had generally chartered out their fleet of VLCCs on the spot market on a voyage charter basis. Fuel consumption had therefore not generally been a matter to trouble charterers. But in October 2016, owners changed their trading strategy and they decided to look to charter out their VLCCs on a long-term charter basis. That, of course, required warranties to be provided as to speed and consumption, amongst other things. Following the change of approach, details of vessel speed and consumption capabilities were circulated to the market. And as Celine will explain in more detail, the figures were said to be based on average of last 3 voyages. In fact, they weren't, but instead were based on the vessel's sea and shop trial data, which had been validated not against the last 3 voyages, but against the 3rd to 6th most recent voyages. Anyway, attempts to find a charter were successful and the vessel was delivered in February 2017. But throughout the life of that charter, the vessel consumed bunkers in excess of the warranted levels. Charterers complained almost immediately, indeed as early as March 2017, so a month after delivery. They were claiming that the vessel's consumption capabilities had been misrepresented. But whilst the charters repeated this allegation on several occasions, reserving their rights when they did so, they continued to employ the vessel in the charter for another 7 months till September 2017. It was only then, after a particularly bad bout of overconsumption, that charterers refused to give further orders until the issue was resolved. A standoff ensued between the parties, and that ended in charterers purporting to rescind and or terminate the charter for repudiatory breach in mid-October. Owners claimed damages for breach of charter. Charterers defended and advanced a counterclaim based on fraudulent misrepresentation as to the vessel's consumption capabilities. And so battle lines were drawn. Now, the first issue before the court was as to what representations owners had actually made. And on that issue, Celine, can you tell us how that unfolded before the court?
Yeah, of course. So as you've said, Rob, during the fixing of the charter, owners, so SK, provided speed and consumption warranties. And the allegation raised by charterers was that owners had made fraudulent misrepresentations as to the vessel's actual consumption. And that might be thought to be a rather specific point, and it is. But in assessing whether or not there had been actionable misrepresentation, the court dealt with various issues which have much broader contractual applicability. And a key point of interest in this case is considering the position where a party offers to contract on certain terms. In what circumstances would the court imply a representation of fact relating to the subject matter of those terms? So a reminder of the general requirements for misrepresentation: the offeror makes a representation, and that's a statement of fact which is intended to be relied upon as true. That representation is false. The representee is induced to enter the contract as a result, and they suffer a loss accordingly. Now, for the representations in this case, Charter has said that there were express and implied representations. The express representations went to the vessel's speed and consumption, and as you mentioned, that was said to be based on information that had been circulated regarding the vessel's historical consumption, and it was said to be the 3-voyage average statement, and based on that. But there were also said to be implied representations in that the warranties being put forward by owners accurately reflected the vessel's consumption. Now, Charter has had quite a strong case on the express representations being made in relation to the vessel's historical consumption data. The fact that they said it was based on the average of the last 3 voyages was found to be representational in nature and indicated that the data reflected, or at least was consistent with, the vessel's consumption and the vessel's recent historical performance. Now, owners tried to put forward the suggestion that the speed and consumption data should be understood solely as a statement of the warranties which owners were willing to offer, and not as a representation of fact as to the vessel's actual performance. But Mr. Justice Foxton wasn't having this, was he, Chris?
No, we were kicked into touch on this particular point. There was an old decision of Mr. Justice Hobhouse in a case called the Larissa that we tried to rely on. In that case, a ship owner was being accused of pre-contractual misrepresentation, and the ship owner argued, and Hobhouse agreed, that what the ship owner said was really just statements as to the terms of any consumption warranties in the charter that was being proposed. Now, the problem we faced was that the wording of the relevant communications in the Larissa obviously lent itself to such an interpretation. However, on the Sea Challenger facts, the consumption data that was circulated to the market was, as you've said, Celine, accompanied by the wording based on last 3 voyages. Well, that wording clearly indicates that the figures aren't actually just contractual warranties, they're purporting to be the actual data of the vessels. So we were facing somewhat of an uphill battle, it might be said, as to whether or not there was an express representation of fact.
Yeah, and so I guess in light of that, people might wonder why Charter has included the implied representation point, because if there was a strong argument on the express representation, why would you need it? But the reason why they did that, on my understanding, is that the Charter's argument on express representations fell down at the inducement stage. And in testing the issue of inducement, the relevant question is not what the misrepresentee would have done if he had known the true position, but what he would have done if the representation had not been made at all. So here, if the express representations as to the vessel's recent consumption had not been made, would charterers have still entered the charter? And normally charterers would only get the speed and consumption warranties. They wouldn't typically be provided with this actual historical data. So they were going to have a really hard time in proving they'd been induced to enter the contract as a result of the express representations being made. So to get around this, charterers said implied representations arose from the warranties themselves, in that the warranties were said to be accurate or reflect the vessel's capabilities. And since that representation would form part of the warranty, it would be tied into the warranty, then it would be much harder, or I think impossible, charterers said, to remove that warranty and to ask what would have happened if owners had not been willing to offer it. And this is something that Mr. Justice Foxton actually mentions. He says that it would be a commercial necessity to have those warranties. So by tying the representation to the warranty in that way, charterers made their argument on inducement a little bit easier. So the court really had to determine the question of whether an offer of a speed and consumption warranty, in this case a time charter, contained any representation as to the vessel's performance. And this has only been considered in one previous case. That's the case you mentioned, Chris, the Larissa. I think, Mark, you've looked at this.
Yeah, I did have a look at the Larissa, and that was a case where the charterer was a little bit stopped on the express warranties. So it tried to get around that by arguing for a representation. But as Chris has alluded to, the wording of the pre-contractual emails in the Larissa case were a lot stronger for the owners than they were for the owners in the Sea Challenger. So for the speed and consumption data that was circulated in the Larissa, the words owners to guarantee were used alongside it. So Mr. Justice Hobhouse on those facts, I think, had very little difficulty in saying there was simply no representation in any of the emails. And my reading of the Larissa is therefore that it's really just a case on the construction of the relevant emails and whether they contained an express representation of fact. But in some of the cases that I've looked at this point subsequently, and in a more general context, it seems to me that the Larissa has potentially been given something of a wider ambit. And one of those cases that I think Rob is going to consider is the Kingscroft case. Rob?
Yeah, thanks, Mark. That's a point which throws up a question of some general importance, which is this. Where a party offers to contract on certain terms, in what circumstance, if any, will the court imply a representation of fact relating to the subject matter of those terms? Now, as you said, in his judgment, Mr. Justice Foxton referred to the Kingscroft insurance case. That was a judgment of Mr. Justice Moore-Bick. And what he said was that by offering to contract on certain terms, the person doesn't normally make any representation about the particular subject matter of those terms or obligations. And certainly, Mr. Justice Moore-Bick's view is that was the proposition for which the Larissa stood. However, just to complicate things, he noted that this position could be different where the offer included terms which are intended to stand as representations in the contract as ultimately concluded. And an obvious example is something that might appear in a preamble. However, he then went on to say, to further complicate matters, that a rather different question was whether simply by offering to contract on certain terms, a person by implication represents that he intends to perform any contract made on those terms and believes that he is or will be able to do so. Now, on this question, by contrast, Mr. Justice Moore-Bick said that because, after all, that is the basis on which a person expects the offeree to judge his offer, he saw no reason why that person wouldn't be held to have represented as such. So it's complicated, and those are the parts of the Larissa and the Kingscroft that are relevant. And Celine, how did the court deal with all of this?
Well, essentially, the court, Mr. Justice Foxton, said that there were good reasons why the mere offer of a speed and consumption warranty, particularly a continuing warranty, should not of itself be held to involve any implicit representation as to the vessel's current or recent performance. And he also said that if he had been required to, because in this case, charterers had essentially said that the Larissa was wrong or it could be distinguished, if he had been required to, he would have been reluctant to depart from the Larissa in any event. For the reasons that you've given, it stood the test of time, and it has been cited in subsequent authorities such as Kingscroft Insurance with approval. So those are really the findings. I mean, the good reasons in summary was said to be that the language of such an undertaking, so a warranty, is inherently promissory, and it's expressed in relation to the future, so the performance during the chartered service. And the attempt to imply a representation raises a number of practical questions. So, for example, the date at which any particular level of performance is said to have been represented. This could be the date at which the charter was fixed, the date of the charter period commencing, etc. And also another practical concern is that given speed and consumption warranties are often the subject of negotiation, so weather permitting, for example, is something we often see, that variable, or that such variables, would really be inconsistent with the offered warranties involving a representation as to the vessel's consumption. So the answer is that no implied representation as to the vessel's actual consumption arose from the speed and warranties given in this case.
Thanks. And as Celine, you mentioned earlier, without an implied representation, the charterers were in real difficulty as regards their case on inducement. The owners, however, as well as defending the case on inducement, had other lines of defence. And one of our follow-up lines of defence was that, well, even if there had been an actionable misrepresentation, charterers had affirmed the contract and so were not entitled to rescind it. And the case gave rise to some interesting issues on affirmation, which I think the Stig's going to consider now.
Yeah, thanks, Chris. So the case raised a couple of interesting points on the topic of affirmation. First, what level of knowledge does the innocent party need to have had to be taken to have affirmed? And is that to be judged objectively or subjectively? And secondly, what is the effect of an express reservation of rights? Does that prevent conduct which would otherwise be affirmatory from amounting to an affirmation? Before getting on to the first of those, it's probably helpful for me to quickly recap facts that were most relevant to the issue of affirmation. The misrepresentations of fact that the charterers managed to establish were made on the 22nd of November 2016 in a letter, and the charter party was entered into on the 6th of December 2016. But it was only on the 19th of October 2017 that the charterer said, well, now we rescind, or alternatively, we terminate for repudiatory breach. And in that interim period of 10 to 11 months, there'd been a lot of correspondence between the owners and the charterers. The charterers had sent various messages alleging misrepresentation and threatening to rescind or terminate, including many which contained reservations of their rights. And also importantly, on the 13th of July 2017, which was about 7 months into the charter service, the charterers had fixed the vessel to Trafigura for a voyage from Tanjung Pelepas in Malaysia, which involved committing the vessel to quite a long fixture, repositioning it from Europe to Southeast Asia, and a host of interactions with third parties. So against that backdrop, the owners argued that the charterers, by their delays and their employment orders, had elected to affirm the charter party and therefore lost their right to bring it to an end, whether by rescission or termination for repudiatory breach. So the first question which arose was, what level of knowledge must the innocent party have to be taken to have affirmed? And is that something which we should judge objectively or subjectively? And Chris, I understand that it was quite interesting how this came up in the case and the parties kind of had to put their arguments quite carefully on this point.
Yeah, well, both parties were having to try and chart quite a narrow course on this particular point. I mean, as you've mentioned, the charterers had said in the summer, they'd written various communications saying things such as, there can be no doubt that the vessel's consumption was misrepresented. Now, once the dispute blew up and we were arguing affirmation and the like, charterers appreciated, oh, well, we're going to have to say that we didn't know that there was a misrepresentation, so we didn't know that we had the right to rescind. But we were waving communications such as that in their face. And so they were having to argue during the cross-examination, well, we may have said that, but we didn't actually know the case. We just suspected that. And so they were trying to tap dance quite finely on that point. On the other hand, we were obviously trying to be a little bit delicate as well, because it was our primary case that there had been no misrepresentation. So I was having to cross-examine on the line that, well, that thing that we say didn't happen, i.e. the misrepresentation, if it had happened, nonetheless, you knew about it full well, which again was quite a difficult chart to course. But anyway, Mark, so when considering the objective-subjective point, what was the judge's view as to the law?
Yeah, well, the judge referred to various authorities on knowledge, and he distilled a series of points or tests. But first, he said that knowledge is essentially a jury question, so it's a question of fact. The innocent party must be aware of the facts giving rise to the inconsistent rights, and must be aware of the legal rights to which those facts give rise. He said that knowledge means more than simply suspicion, but it can be something less than absolute certainty. And what the innocent party must have is a firm belief that there has been a misrepresentation and sufficient justification for that belief. But it seems to me that the court didn't expressly decide whether the test for knowledge is objective, i.e. judged by looking at what the innocent party did and said, or subjective, i.e. does it only matter what was inside the relevant individuals' heads? The judge was certainly clear that when it comes to communication of an election, this is to be judged objectively, i.e. did the party speak or act in a way which would be reasonably be understood as consistent only with that party having made an informed choice to treat the contract as valid. But what do people think about the objective versus subjective question on whether the innocent party had the requisite degree of knowledge? And how do we judge that in a particular case?
Well, I mean, I agree with you that the court didn't expressly say so in terms, but from the analysis, it seems to me that knowledge must be subjectively judged, particularly if the test is said to be one of firm belief. I mean, so presumably, if the court finds that the innocent party did not subjectively know that it had the right to terminate, then the innocent party cannot have lost that right through affirmation. I mean, Chris, Rob, you're the Silks. What do you think?
Well, I think it's a difficult question. I mean, English law tends to prefer the certainty of an objective approach over that of a subjective one. But here on the question of knowledge, it does seem to me that it must have a subjective element at least. I mean, if it was purely objective, I mean, I wonder whether you start to blur the lines between the knowledge issue and the communication of election issue. So I think it's difficult. But Mark, on that topic, what did the judge find on the facts regarding knowledge and the communication of an election?
On knowledge, the judge said that he was satisfied that certainly by the 13th of July, which is when the Tanjung Palapas voyage was fixed, the charterer's suspicions had moved to a state of knowledge that there had been a misrepresentation. And he pointed out three things. First, the charterers had been monitoring the performance of all four of the VLCCs and noticed underperformance. Secondly, they'd received analyses from a company called Accuritas, confirming their own analysis of underperformance. And thirdly, the masters of two of these vessels had effectively admitted in correspondence that their vessels couldn't meet the figures represented. And therefore, there was enough to satisfy both an objective and a subjective test for knowledge. On the issue of communication of an election, the charterers had demanded substantial performance of one of owner's central obligations under the charter by fixing it to Trafigura for the Tanjung Palapas voyage. So he said that subject to the effect of a reservation of rights, this act of seeking to make a profit from the charter and bringing the owners into contractual relations with third parties would amount to a clear affirmation of the contract. And that point brings us on to the next question on affirmation, which is, what is the effect of an express reservation of rights? Does it prevent conduct which would otherwise be affirmatory from amounting to an affirmation? And as the judge noted, there's been very little judicial consideration of the effects or even of the juridical basis of such reservations. And Chris, I believe this point took on an unexpected importance during the hearing, didn't it?
Yeah, I mean, it had always been in the arena. I mean, the charterers had pleaded it and referred to it in their skeleton argument. But I mean, to be quite frank, personally, I thought it was a bit of a duff point. I mean, just simply because you'd had all these communications saying, do this, do that, etc. And at the bottom, they just had like in a form of boilerplate text, the word, by the way, we reserve all our rights. So I thought, well, come off it. That's just kind of like a phrase lawyers regurgitate frequently. But, you know, ultimately, you've got to look at the substance of what was being said. So we could ignore the reservation of rights. But then just before closing in the trial, Mr. Justice Foxton said, well, that was one of the points on which he would like some assistance from the parties. So it was like, oh, cripes. Obviously, he thinks there might be something in this and we better go and do some research on the law.
Yeah, clearly quite a lot of research was done in the end because the judge managed to identify a couple of different theories on this. He said that one theory is that a reservation of rights should be effective because it deprives communications or conduct of the quality of unequivocality that's necessary to constitute an election. So, for example, there's some authority that an insurer can make a payment under a reservation of rights, and that will be effective. And also, a reservation of rights can be effected to kind of hold the ring and prevent a mere delay from becoming affirmatory in a delay case.
Yeah, Mark, but sorry to interrupt. I mean, that's true, but it's also, I think, been rejected in the landlord and tenant context, my specialist subject, obviously. But I seem to recall the judge discussed authority in that field to the effect that affirmatory conduct by a landlord, for instance, accepting rent when there's a right of forfeiture of the lease, doesn't cease to be affirmatory just because the rent's received under a reservation of right. So there is some contrary authority, I think.
Yeah, that's right. Although it might be said that that rule is actually just confined to landlord and tenant law. And if you say that, then you could make a case for the first theory being valid elsewhere. But I do take your point, Rob. And the judge said there's also a different theory, a second theory, which doesn't really suffer from that problem, which is that there can be no magic in a reservation of rights anyway, because some acts will just be so intrinsically affirmatory that performing them will cause the contract to be affirmed, even if they take place under a reservation of rights.
Isn't this the really good quote from Haynes and Hurst? Something like, if a man eats his cake, he will find it gone, even if he eats it without prejudice.
Yeah, so you can't have your cake and eat it. And I think that's essentially what the judge thought in this case, the C challenger. He thought that whilst outside the landlord-tenant context, a reservation of rights will often have the effect of preventing subsequent conduct from constituting an election. This isn't an invariable rule, and ultimately the court has to have regard to all the material, including any reservations. So a reservation is more likely to be effective if you reserve your rights while you're exercising contractual rights just to get hold of information from the counterparty, or perhaps if you're performing only your own obligations whilst reserving your position. But a reservation is less likely to be effective if what the innocent party is doing at the same time is demanding substantial contractual performance from the counterparty, and particularly so if that's going to affect third parties' positions significantly. So what do people think about the court's analysis of reservations of rights?
Well, I think for my part, it's a wake-up call, and the takeaway seems to be that we need to be very careful with reservation of rights because they don't always do what they say on the tin. And I guess it's a question of law objectively judged, whether in any circumstance and looking at the totality of the evidence, whether there's been a communication of an election. And simple truth, I guess, in some cases, actions will speak louder than the words of reservation. So I think we all need to be very careful about these reservation statements.
Yeah, I would agree with that. I mean, I think that the upshot of the judge's findings in his view of the law is that in a case where the actual conduct relied on as being affirmatory is more equivocal, closer to the line, then the reservation of rights is the kind of thing that might tip it on the side of saying, well, there's no affirmation. Whereas in a case such as this one, where you've got a vessel being ordered on a voyage, then actually that's so fundamentally pointing only one way, i.e. keeping the contract alive, it's difficult to see that how you can make that an ambiguous bit of conduct simply by saying at the same time we reserve our rights.
Yeah, fair enough, Chris. Now, since you're on your feet, maybe you can walk us through or talk us through the remedies issues that arise, rescission, damage for misrepresentation, and so forth.
Yeah, sure. So this was the final suite of issues that arose on the misrepresentation point, namely, well, if there had been an actionable misrepresentation, what remedy should the court grant? And the charterers were asking for the charter to be rescinded. Now, the court's decision on remedies was obiter because it had found that there was no actionable misrepresentation in light of its conclusion on inducement. But its decision on the question of rescission was actually doubly obiter because, as Mark's just discussed with us all, the court also found that there had been an affirmation which would have ruled out rescission if there had been a misrepresentation.
Point of order, Smith, is double obiter really a thing?
Yeah, that's a real concept. Look back at the white book, about part 92, something like that. Have a look at that.
I'll have a look later.
But because the points arising were interesting and had been fully argued, notwithstanding their double obiter status, the court decided to express a view on them. Now, The most interesting and difficult point concerned whether the court should exercise its discretion under Section 2.2 of the Misrepresentation Act to refuse rescission and to award damages in place thereof. Now, the reason why it was quite a difficult point in this case was this. The charterers had, as Mark I think mentioned earlier, on the 19th of October said, we're rescinding. We're going to walk away from the contract. And they had done that. Now, if the court subsequently, some 2-3 years later, decided to refuse rescission and award damages instead, well, it must follow from that that the charterers had no right to rescind and no right to walk away from the contract. So the effect of the court exercising its discretion in this manner would be to automatically place the charterers in repudiatory breach of contract. And so the question that the court had to consider is, well, when exercising the discretion to refuse rescission, is this something that should be taken into account? And you can imagine it's quite the dilemma, because this is a question that only arises if an actionable misrepresentation has been found to exist. In other words, if the representee is, at least to this extent, the innocent party. It might be said to be compounding the representee's misery if it said, well, yeah, true, there is a misrepresentation, but nonetheless, we're refusing rescission and, sorry, as a result, you're in repudiatory breach of charter. So how did the court decide this pretty tricky point, Rob?
Well, the court held, drum roll, attention, it was an irrelevant consideration. And it did so essentially for two reasons. The first is, if you look at the wording of Section 2.2 of the Misrepresentation Act itself, it specifically identifies as factors to be taken into account the loss that would be caused to the representor if rescission is ordered, and the loss that would be caused by the misrepresentation if the contract is upheld. But the absence of any reference to the loss caused to the representee if rescission was refused indicated to the judge that damages in lieu of rescission weren't designed to protect the representee against the consequences of rescission being refused. And hence he felt that those consequences were not a relevant factor. Secondly, he held that save in cases of fraudulent misrep, which actually fall outside the scope of Section 2.2 in any event, rescission is a remedy that's affected by the court, not a self-help remedy that can be exercised by one of the parties. So consistently with that, the judge was of the view that representees shouldn't be seeking to rescind a contract without the assistance of the court. And if they did so at their peril.
Rob, or Chris actually might be better, did the court's conclusion on this feed into their analysis of the damages to be awarded in lieu of misrepresentation? Because, I mean, presumably the charterers could argue that such damages should take into account the losses caused by the court's refusal of rescission, including any liability that they might have to owners as a result.
Yeah, well, actually, that leads quite nicely onto the next point I was going to consider, because there is an overlap between should rescission be refused and the question of, well, what's the measure of damages if you do refuse rescission? And as you say, Celine, the charterers were arguing that, well, if you refuse rescission, you should nonetheless award us damages to effectively put us in the same position as if there had been rescission. Now, on the question of how damages are to be assessed on this heading, the good news is, unlike on the previous point, there was an authority to assist us, a Court of Appeal decision in a case called Williams-Sindel. The bad news, however, is the Court of Appeal's decision in Williams-Sindel has been roundly criticised by most of the commentaries. McGregor on damages describes the decision as dangerously faulty. But anyway, well, what William and Sindel said, it said that firstly, that damages should not be designed to put the representee in the same position as if rescission had been granted. The logic for that perhaps being fairly obvious in that, well, if you're going to award damages so as to effectively recreate rescission, it defeats the point of refusing rescission in the first place. You might as well have just rescinded. The second bit of William and Sindel in terms of the assessment of damages is the Court of Appeal said in those facts, well, you should only focus on the losses caused by the misrepresentation or the subject matter of the representations, and you should ignore any other losses of the representees which are independent from that misrepresentation. So applying that, for instance, in the context of a case like Sea Challenger, you've had the market for the vessel plummet. That's a loss that the charterers have suffered, which is completely unrelated to the overconsumption warranties. It's not suggested that the market plummeted because of bunker prices. And so that's something which should be ignored when it comes to the assessment of damages. The third part of the reasoning in William Sindel, and this is the one that's really controversial, is the suggestion that damages under section 2.2 should be assessed on the contractual measure. Though there is a suggestion that that's not what the Court of Appeal was saying. They were simply saying that the contractual measure should be identified and set as a cap on liability. But the reason it was suggested that the contractual measure would be wrong, and the reason why William Sindel's been criticised, is adopting such a measure could have the result that damages under section 2.2 for an entirely innocent misrepresentation could end up being greater than they would be under section 2.1 of the Misrepresentation Act for a negligent or even fraudulent misrepresentation. So that's really why William Sindel's been so heavily criticised. Now, as it happens, because of the charterer's evidence, because of some of the findings of fact that the judge came to, and also because of the way the charterers were actually putting their case, the court in the Sea Challenger was able to skirt around the difficulties created by William Sindel and its subsequent criticisms, because the court said, well, actually, if you look at what the charterers are saying, and if you look at my finding of the facts, there's no difference between a contractual measure and a conventional reliance measure. So whichever way I go, I don't need to be troubled by William Sindel, whether it's right or not, because it's the same damages either way. So the court could effectively duck that particular issue.
All right, thanks, Chris. That's interesting stuff. Now, I think we've reached the stage where you've heard more than enough from us. There are, as I said, a number of other issues arising in this case, but we probably don't have time to cover those. So what I'm now going to do is throw it open to the floor. We've had a number of questions in, so I'm going to have a look at those and then choose a lucky or unlucky victim to answer them. So the first question that's been raised from Vaseline Basilev, thank you for the question, is the following. Were the initial sea trial speed and consumption figures also mentioned in addition to the average of the last 3 voyages when circulating the vessel? I think Chris, as counsel in the case, is best placed to answer that one.
Yeah, sure, I can take care of that one. The answer is no. The data circulated to the market was just a series of consumption figures at various different knots, speed-wise, and that was said to be data on the last 3 voyages. There was no separate sea trial data actually provided, and as Rob mentioned at the top of this webinar, part of the problem that my clients faced was that actually the data that was said to be based on last 3 voyage was nothing of the sort. It was in fact the sea and shop trial data as subsequently adjusted after 6 and 12 months of service of the charter. And that data was just checked against certain voyages which weren't the last 3 voyages. So whilst actually the data presented was effectively sea and shop trial data, it wasn't said to be that. It was said to be based on the last 3 voyages. So as the court concluded, that's what any reasonable charter would have concluded it was, simply data taken from the average performance over the previous 3 voyages.
Thanks, Chris. Now, next up, I think we'll pick on the Stig. How about that? Okay, Mark. It was mentioned that the test for affirmation might operate differently in practice, depending on whether it arises in the context of a repudiatory breach or a right of rescission. In what ways could it operate differently in those 2 contexts?
Yeah, so it's a good question. The judge said that the doctrine is the same in both contexts. It's all about the law relating to the election between inconsistent rights. But he did discuss one example of how the same acts or omissions might give rise to different results, and that was delay. So I think if you consider the issue of delay in the context of termination for a putative breach, the judge says that's not a kind of one-way bet, because the contract will only ever terminate from the moment that the breach is accepted. So if the innocent party does delay, it takes the risk that the contract might be brought to an end for some other reason in the interim period. For example, there might be frustration, or the other party might even exercise a right to terminate for another reason. And also in that repudiatory breach context, the innocent party might delay in order to allow the guilty party a bit more time to perform. But the judge said if you looked at delay in the different context of rescission, you can't, of course, cure the misrepresentation by further performance in the same way. So the judge says that's kind of a one-way bet if the innocent party is allowed to wait and see how well it does under the contract before it tries to rescind. For all that time, the misrepresentor potentially suffers prejudice if it's continuing to perform, but the contract might later be unwound by rescission. So I think the implication from the judgment is that delay is one example of an act, or maybe you call it an omission, that would be more likely to prevent a right to rescind for misrep than a right to terminate for repudiatory breach.
Tricky stuff. Wow. Okay, thanks, Mark. That's much appreciated. Now, talking about tricky questions, Celine, as I said, wanted to answer all the difficult ones. So here's one for her. What would you advise the charterers to do and when?
It's a tricky one, Rob, because I mean, you sort of have to, in this case, you're sort of stuck with it. But in terms of going forward, I mean, they might have a claim for breach of warranty and things like that. And if it was such a fundamental breach, then it might actually give rise to terminate the charter. But really, what a party should do in a situation is look at squaring up the provisions in the contract for what happens when there is a breach of the warranty, rather than seeking to rely on some sort of representation that may have occurred beforehand. You can either ask for the actual data at the beginning, and I think Mr. Justice Foxton says you can ask for this to be a condition of the contract, or really look at the data and evaluate that. But I mean, it's quite unlikely in the way in which charters are fixed, as I said at the beginning, that you would get that data. So if you're not going to be able to do that, when fixing a charter, you should focus on the provisions that will kick in if there is going to be a breach, and make sure that those are going to essentially assist, whether by way of sort of money back for overconsumption, really square up those provisions. But there's not a lot you can do, because if it's so minor, if there's only a tiny bit of overconsumption, that the difference wouldn't have essentially induced anyone to enter the contract, it's very unlikely that you would succeed on any sort of representation argument. And I mean, Chris, maybe to ask you a second point, do you think that this judgment essentially closes the door to charterers seeking to do that? Based on the Larissa and based on the judgment in this case? I mean, what would you say to that?
I don't think it necessarily closes the door, because I suspect this type of thing as to the existence of pre-contractual representations, it is always going to depend on the actual facts and what was said. And again, it goes back to the point that I think there are going to be plenty of cases where you are going to be able to find an express representation of fact, and where charterers can maneuver themselves so they've got one by asking for the historical data. But they're always going to come a cropper, probably in this context, on the inducement issue, because as was accepted by the witnesses, by the judge, by like most of the parties, normally when chartering a vessel under time charter, a charter will be told what the warranties are going to be for consumption, but they won't be provided with any actual data. And if that's the default position, then it's very difficult for them to say that if they hadn't been provided with actual data, they wouldn't have entered into the charter.
I think, have we lost Chris at that stage? I think we may have done. Anyway, there we go. He, I think, was probably just about through in his answer to that question. Oh, he's back with us. Welcome back, Chris.
Yeah, I don't know what happened there. Maybe the judge kind of heard and somehow kind of interfered. We had the handing down consequentials hearing the other week, and The judge indicated that he'd read a kind of little article I'd written about the judgment, which was somewhat embarrassing. So who knows, maybe he's listening to this as well.
Excellent. Well, listen, the other question, or another question we've had is, what was the significance of the allegation of fraudulent misrep? Presumed damages as an inadequate remedy, or was there an exclusion of reliance on pre-contractual representations? Can you help on that one, Smithy?
Yeah, well, at risk of getting booted out again, kind of obviously people heard enough of me. I think obviously the charters didn't come out and say why tactically they had chosen to go down the route of alleging fraud, because as it happens, the allegation of fraud only came in via some reasonably late amendments. But my take on it is that they did it to help them on inducement, because I mean there's House of Lords authority which says there's a presumption of inducement in the context of a fraudulent misrepresentation. And what's worse for a party in the owner's position, it's a very strong and difficult one to rebut. So I think they were hoping, because I think they appreciated they had inducement difficulties, but thought that if they can show that the representation was fraudulent, that would get them over those difficulties because of the strong presumption. The other reason why they might have gone down the fraud route, other than obviously prejudice, because if they, there's a fraudulent misrep found, the court might not be too inclined to find in my client's favour, was that it would rule out damages being awarded in lieu of rescission, because the court's discretion to not rescind the contract doesn't exist for a fraudulent misrep.
Yeah, that's section 2(1) of the Misrep Act, isn't it? It
Correct.
just applied fraudulent, yeah.
10 points.
But on the facts, I mean, Chris, do you think anything less than fraudulent misrep would have really represented the case that was advanced? I know it wasn't accepted, but would it have been runnable, do you think?
I mean, yes, because the difficulty, the difficulty for the charters is they didn't know what had happened behind the scenes. They had no idea on what basis the data had been drawn up and what the belief within SK were. And so they'd kind of like started this case alleging misrep, but not knowing what the inner workings were. And so that's why they had started off on a negligent basis, because obviously you can't, if you don't know what's happened, you can't allege fraud. So they alleged negligence, saying, well, you said that this was how it was going to consume this. You said how this is how it done historically, but that simply can't be right because of the massive overconsumption we experienced. So I think they had to start the case on that basis. And then as kind of matters went on and it didn't settle and things like that, and when they also got our witness evidence and our disclosure, I think they realized that tactically they probably had to go down the fraudulent misrepresentation route because of the difficulty in inducement. So yeah, I think kind of anything less than fraud is always going to be very difficult in the inducement context, because you don't have the benefit of the presumption. And you don't have the goodwill of the court, because the court's always going to want, never going to like the idea of a fraudulent misrepresentor saying, well, doesn't matter anyway. We may have deliberately and dishonestly hoodwinked you, but nonetheless, it made no difference to you. And it's not a finding you can imagine most judges wanting to come to.
Yeah, great. Okay, thanks for that. Now, if anybody has any more questions, please put them on the Q&A. Whilst you're doing that, I was just going to ask Chris if he could update us on the prospects of any appeal from this particular decision.
Well, watch this space. So there was the consequentials hearing last week. Neither party has asked for permission to appeal yet, but they've reserved the right to do so from the Court of Appeal. So are undecided at the moment.
All right, so watch this space. There may or may not be a further a quadcast on the Court of Appeal's decision in the Sea Challenger. All right, well, listen, I'd just like to bring the session to a close, if I may. Thank you very much for everybody who has tuned in and has listened. If anything does occur to you after this session, please feel free to email any of us with any further questions, thoughts you may have. I'm sure we will be more than happy to answer them. All that remains for me to do is say thank you once again. There will be another shipping quadcast in a month or so. Details will be circulated as usual. But with that, I say thank you very much and goodbye.
Yeah, thank you very much, everyone.
Thanks, everyone.